Let me put it on record also. Right, we are. So standard, Grant, thank you very much for being part of the symposium, and the way what Peter is put across. I mean, there is going to be an interesting discussion, and of course, what all you're going to bring in from the New Zealand perspective. So thank you very much. Please introduce yourself, and this is your presentation up till you don't ask me to come in. Please.
Thank you. Tēnā koutou, everyone. My name is Dr. Grant Morris. I'm an Associate Professor of Law at Victoria University of Wellington, so the law school in the capital city of New Zealand. I am also a mediator, in particular interest in employment or workplace mediation. Before I joined the law school, I was an interest-based negotiator for the government in our treaty settlement process. So that's the Treaty of Waitangi, which is our founding document where the British Crown made a treaty with the Indigenous peoples of New Zealand, the Maori people, and there are grievances that are being negotiated and settled through that process. So that's where I was before I came to the law school. Before that, I did a PhD, helpfully for this talk, in legal history. So I have a keen interest in the history of mediation, and in particular its development in New Zealand. And I thought, given Vikram's theme for these talks, I'd focus as much as possible on that development and on the cultures and traditions of mediation in New Zealand, and as much as possible make connections with the rest of the world as well. If you do find yourself getting very interested in mediation in New Zealand during this talk, I can recommend this book here, which is Mediation in New Zealand by myself and my colleague Annabelle Shaw, who is an academic and mediator in Wellington as well. And we wrote the book 3 years ago because there hadn't been a book written solely for the New Zealand mediation market. And we wanted to write one which was very much focused on New Zealand, and also one that brought in a lot of history and a lot of jurisprudence, and also mapped out the mediation market in our country as well. So I thought I'd start today talking a little bit about the long-term traditions that we have in New Zealand, and then I'll bring it more up to date and talk about the modern mediation movement in New Zealand, and hopefully you can make some connections with your own jurisdictions and see where there are differences and similarities. So in New Zealand, and I'll assume that you have a general knowledge of the basics maybe of New Zealand, but not too much about the history. Most archaeologists and anthropologists think that New Zealand was first settled around about the 13th century by Pacific voyagers from the eastern Polynesia, so Cook Islands, Tahiti area. And those people became the Maori people of New Zealand, the indigenous people of New Zealand. And up until really Captain James Cook and his voyages beginning in 1769 in New Zealand, Māori developed their own distinct society, and that included dispute resolution. There were a number of different periods that one can map out in that development, from the early days where Māori were obviously adapting to what was quite a different environment to the tropics and the smaller Pacific Islands, to a more settled society where warfare became more prevalent than it was at the beginning, and then to the society that Cook would have viewed when he arrived in 1769. The basics of Māori society were governed by key philosophical concepts, is what we call, or what is called Māori tikanga, or the way of doing things. So things like mana, the Māori word for that could mean prestige or status, was vitally important in this society, as was tapu, or what could be translated as sacred. And a number of these key traditions govern the way that Māori interacted and resolved disputes as well. In terms of mediation, I mean, I think it's important to note that when we talk about mediation today in New Zealand, we're really talking about a Western construct and the way we use it in our legal system. But if we were to compare, take, say, mediation and litigation, both commonly used in New Zealand, we'd have to say that mediation would be closer to that Maori traditional dispute resolution approach. So a approach grounded more in the community, in peaceful resolution, in trying to resolve disputes before you have to go to something higher and more informal. I mean, that informality and rigidity of the of litigation has been a major issue for Māori and had a major impact since it was brought in 1840. And I mean, there's a whole rich history and troubled history of the New Zealand legal system being implemented in this country, which I'll touch on, but I won't talk too much about that today. What I do want to note, since I'm giving my talk here, and it makes sense to focus on what I'm studying, I'm actually working on a research project at the moment in the Chatham Islands. So I don't know how well you know your Pacific geography, but the Chatham Islands is actually part of New Zealand, but it's approximately 800 kilometres east of Christchurch, and it's a number of small islands that sit out to the east of New Zealand. And the indigenous peoples of the Chatham Islands, or Rekohu as it's called, the Moriori, developed their own dispute resolution tradition. And when they started to settle out there, and the archaeology and the traditional stories of the Moriori suggest that it was peopled from New Zealand, but also possibly directly from the Eastern Polynesia as well. But given the small population and the lack of the limited resources, the Moriori developed a non-violent culture early on. So we're talking around about the 15th century AD. And that non-violent culture was based in a philosophy which said, when we have a dispute, we will not go into warfare. We can't afford to go into warfare. We may have a ceremonial battle which will end when blood is spilled, but we will keep to the philosophy of one of their elders called Nunuku Whenua, who said, we will live in peace on these islands. And what I'm working with the Moriori trust that's on the island that represents the Moriori people, the indigenous peoples of those islands. What they're trying to do is, as much as possible, resurrect that tradition and tell people about it, because it's not only one of the earliest pacifist and, I would argue, interest-based dispute resolution cultures around the Pacific, but I would say one of the earlier ones, in the world as well, which really consciously took a pacifist approach to life, and that informed its dispute resolution as well. It developed quite differently to Māori dispute resolution tradition, in the sense that, as you'll know, Māori was not a pacifist culture. It was a martial culture in many ways, while still having, obviously, peacemakers as well. But that's a project that I'm working on at the moment, and I'll be going out to the Chatham Islands in a couple of weeks, actually, on the little plane. It's always a bit of an adventure. So those are two examples of Indigenous cultures of New Zealand. So the much more well-known Māori culture, and the lesser known, but very interesting for us as mediators, the Moriori culture of the Chatham Islands. Now, I want to talk more about the way in which mediation's developed in our country. In some ways, we've been very much a follower of the modern mediation movement, and in a few respects, I think we've been a leader as well. So let me give you some examples of where I think we've shown some leadership, and then I'll talk about some other areas perhaps where we very much have followed the rest of the world. I'll start with employment, which is my area of mediation in terms of a practical sense. We early on in our colonial history, so the late 19th century, introduced legislation which gave some legitimacy to unions. This is the 1890s, and also set up an arbitration court to encourage employers and employees to settle their disputes peacefully and to avoid strikes. So that worked quite successfully in New Zealand. And the arbitration court, which is now the employment court, has a long and rich history of about 130 years. And while there have been strikes in New Zealand's history, absolutely, the way in which employment dispute resolution through conciliation and mediation has worked over the years has reduced those. And when we get to round about the 1970s and 1980s, mediation as we know it becomes more prevalent in employment dispute resolution. And particularly during the 1990s, where the union movement is close to dismantled by a more neoliberal statutory regime, we get the rise of the personal grievance, the individual personal grievance, and the mediator resolving those personal grievances rather than it being unionized and the union doing that work. So we still have mediators involved in collective bargaining, but the most of the work for the employment mediator is resolving individual personal grievances. And one of the things that Annabelle and I do in this book is try and map out the New Zealand mediation market. And we have two big advantages in doing that as researchers. One is that New Zealand's relatively small. We have 5 million people, so it's not a huge country. But the second, and possibly just as important, is that we're a unitary state. We don't have any federal system. We have one government in Wellington, and the systems are national. So it's quite straightforward. If you want to look at employment mediation, you just go to the data that's produced by that particular division. And so we were able to estimate that approximately in any given year, we have approximately 10,000 what we might call conventional mediations in New Zealand. And it'd be quite hard to do that, I think, with a lot of countries, given just how vast and fragmented mediation would be. I bring that figure in because approximately half of those are employment. That's how dominant employment mediation is in New Zealand as part of our mediation world. No other area comes close to employment mediation. And so our employment mediators have often acted as the leaders of the New Zealand mediation movement, the trainers, the teachers, and because it's got that history that really, if you want to go back to proto-mediation, it goes back to the 19th century. It's also got a lot of kudos or status behind it. So that's apart from the Māori, Moriori traditions, the employment mediation tradition is by far the longest standing one, especially from a Western perspective. We've always had types of mediation in our legal system from when it was set up, the colonial legal system in 1840. The term conciliation, which, as we all know, is a tricky one to define, has had a role. It's had a role in employment. It's even had a role in family law for quite some time. Unfortunately, in New Zealand, as I know in other jurisdictions, the role of conciliation differs. It's not always the same thing. So I've spent a good part of my academic life teaching mediation and interest-based negotiation and researching it. But if you ask me to define exactly what conciliation means in New Zealand, I I wouldn't really be able to answer that question. So we have that term, but it's really, you know, the negotiation obviously is always been pervasive and prevalent, but mediation for most New Zealanders is a newer thing. I'll give you another example of that, and perhaps where New Zealand has taken a I wouldn't say a leading role, but it has, I think, moved quite quickly, and that's in the area of family law. So we've had mediation in family law since 1980. It's for most of the time from 1980 to now, it was mediated by judges, which was always a little bit awkward. So family court judges would be the mediators. More recently, private mediators have contracted to the government to run family mediation. But for a long time, it was the judges. And the model that we used was originally taken from California, but it was adapted for the New Zealand environment. So mediation in family law has been with us for the best part of 40 years now, but it's never had the success and the high profile that employment mediation has had, I would argue. And it's been, you know, as I said, it's always been a little bit awkward with that judicial involvement. I mean, some judges were very good at it, and some, you know, weren't. Judges aren't appointed on their mediation ability. They're appointed on their adjudication ability. One thing that you may have heard about in relation to New Zealand, and if we use the term, you know, alternative dispute resolution more widely, is our restorative justice traditions. So not mediation per se, but a close cousin. And if you wanted to make strong connections with the Indigenous culture of New Zealand, the Maori traditions of dispute resolution, perhaps it's in restorative justice where those are most clearly seen. So that community approach, that victim-centered approach, that therapeutic and restorative approach is one that you can see in Maori dispute resolution as well, both traditional and modern versions of Maori dispute resolution. And New Zealand was a world leader in restorative justice and criminal law with its family group conferences, which were brought in the 1980s. So for youth offending, and the idea was to have a conference with the victim, with the police, with the offender, with their families, to create a sense of balance, to recreate or to try and find that sense of balance which had been lost. And that philosophy was not just grounded in Western theories of restorative justice, but in Māori theories of restorative justice as well. So while it's not mediation as such, some of our mediators in New Zealand are also restorative justice facilitators. So they take our mediation skills and knowledge and they apply it in the criminal justice system through restorative justice. So that's an interesting cultural tradition as well. A lot of my research over the last 5 or 6 years has actually been in commercial mediation in New Zealand. It was the one area in our market which was opaque because it's not run by the government. So no one keeps any data on how much is done, who does it, what's it like. So I figured it would be a good empirical research project to look at. And so I've been charting the nature of our commercial mediation market, surveys, interviews with mediators, their legal representatives, the parties themselves. That's been the most challenging part, but I have had at least one success with a user case study as well. And we do have a robust and I would say successful commercial mediation market. It's approximately 1,000 mediations a year, insurance, construction in particular, contractual disputes being the most popular overall topic. I don't know if 1,000 seems very much to you or not, but it compares quite favourably to the work that CEDA does in the UK with their studies every 2 years on the commercial mediation market in England. So if you adjust it for population, I think our market compares quite favorably there. So that's been interesting, and it's been exciting to watch, because if we're talking about traditions, you know, New Zealand was set up by Britain, as you know, in 1840 as a British colony. And perhaps of all of the British colonies, New Zealand was the one that was most loyal to the British traditions of doing things, more than Australia, more than Canada, more than many of the other former colonies. New Zealand saw itself as a little Britain. And so our legal system, if you've ever practiced in Britain and you come into the New Zealand legal system, you'll feel right at home. It's very, very similar. And therefore, some of the challenges of bringing mediation in, especially in areas like commercial law, have mirrored some of the challenges I've had in Britain as well, with that very strong litigation, barristerial tradition. I mean, we have a fused profession in New Zealand, so you're a barrister and a solicitor in most cases, rather than the split British tradition. But there's still a very strong litigation culture amongst the law firms. So bringing mediation into commercial law is really a challenge to that tradition. So it's taken a while to convince lawyers that mediation is a good thing. In fact, to be honest, we're still convincing lawyers that mediation is a good thing. When I went to law school in the early 1990s, my law school was brand new. And the founding dean, Margaret Wilson, was very much a fan of mediation and different ways of doing things. And so we were taught way back 30 years ago in different mediation styles, facilitative, transformative, and so on, as law students, way ahead of its time. None of the other law schools were doing it in that way. It was a compulsory paper. Luckily for us, Margaret Wilson became a leading minister in the Labour government, which came into power in 1999. So she was able to introduce, to increase the amount of mediation in employment and human rights and in other areas over which she presided. So, again, challenging those traditions of litigation. But as an academic, as a teacher, one of my main aims is to try and advance that growing culture of mediation in our country. And because I teach hundreds of law students every year, I'm in a good place to be able to do that. I wouldn't say that passion for mediation is shared by all legal academics. I think most are open to it. But, I wouldn't say that the law schools have really gone too far out of their way to promote mediation in New Zealand over the last 30 years, unfortunately. It's there in pockets, but it's not as big as it should be. And I know they've had similar problems in Australia as well. I mean, when we look to Australia, in many ways, we see a jurisdiction which is, in terms of scholarship and teaching, probably a bit ahead of us. Not in all areas of practice, but in terms of the, I suppose, scholarship of mediation. But I know they have issues with their law schools and bringing mediation in there as well. Mediation has a place in other areas as well of our legal system. So very quickly, I'll just outline those. In terms of size, it probably makes sense. Beg your pardon. It probably makes sense to order them. So as I said, employment mediation is by far the biggest, followed by family mediation, in particular custody disputes. So there's a couple of thousand of those a year on average. We have, as I said, about 1,000 commercial disputes, very diverse range of matters. We also have tenancy mediation, but it's probably better defined, I'm going to use that word again, conciliation rather than what we would consider mediation these days. Other, well, some more niche areas, human rights mediation, environmental law mediation. We have mediation for, I don't know if you know too much about our no fault accident compensation scheme in New Zealand, but it replaces to a large extent the personal injury liability tort. So we have an ACC scheme, Accident Compensation Commission scheme, where if you're injured in an accident, the state will pay out through the levies that we pay, and they have a mediation scheme as well for disputes within that. So a lot of smaller areas where there might be a few hundred conventional mediations a year, and that's how mediation has developed. Our research suggests that the number of mediations in New Zealand has probably plateaued over the last decade. There was exponential growth in the 80s and the 90s and the early 2000s. But my research would suggest that has plateaued. What I'm currently working on at the moment, if we're looking at the wider ADR cultural developments, is a thesis that while mediation, as we understand it as mediators, is potentially plateauing, other hybrid forms of consensual dispute resolution are growing. Consumer complaints, call it conciliation if you want, they are growing. Quicker forms of mediation, so quick that we probably wouldn't see them as mediation, they are growing in popularity as well. So our mediation traditions and culture are changing, which is, probably good in the sense that, fitting the forum to the fuss. But another exciting development as well is finally a greater recognition from our tradition, our inherited legal system, inherited from Britain, a greater acceptance of Māori ways of resolving disputes. So instead of having token references to it in the legal system, or instead of it existing outside of the legal system in Māori culture, but not being part of the formal system, it is starting to become a more prominent part of the legal system itself. And one would hope that those consensual restorative traditions get to play a bigger role in our legal system. In terms of our community of mediators, we're a small community. You probably do the quick maths as to how much work there is available given the amount of mediations we have. The employment team is primarily public servants, so they work directly for the government, full-time, permanent public servants. The family mediators are often, in terms of background, family lawyers or perhaps counsellors or social workers, and they contract to the government for their work. The commercial mediators, well, by my research, there's about maybe 50 or 60 New Zealand mediators who will do commercial mediations, but the reality is there's only about a dozen who do it as something close to a full-time job. And they are nearly all ex-commercial law partners, litigators, barristers. So the commercial mediation world in New Zealand belongs to the lawyers. And that's the way it's developed over the last 30 years. We don't, I think this would be interesting given the theme of the seminars. We don't have a tradition of successful community mediation in New Zealand. Processes, often pro bono for neighbourhood disputes or out of...
Can I interrupt?
Yeah.
Yes, your signal I think went off, so it was cut off when you started that we don't have much of a culture of community mediation. It just got cut off after that.
Cool. Is it back again now, Vikram?
Yeah, it's back.
Okay. Yeah, let me know. Otherwise, I'll get my kids to stop streaming the TV next door.
We don't want issues at home. We don't want issues at home. No, we don't want that. We're okay with the disturbance.
Yeah. Okay. Yeah, as I was saying, there's not really a tradition of community mediation. So when I say community mediation, I mean the modern sense of the word. So grassroots, community organizations running successful community mediation schemes, as developed in the United States in the 60s and 70s. We've tried it a number of times. We've tried it funded by the government. We've tried it funded by the community. We've tried pilots, and every time it's failed. And I'm working on a thesis at the moment as to why over 40 years of trying these community mediation schemes, they've all failed, despite the best efforts and despite most of them being free. I don't have a quick answer for you. I think there's possibly two key reasons. One is we have a very successful small claims tribunal system in New Zealand, which deals, it's not a court as such, but it deals with very low level disputes. And often those might be the ones that would go to community mediation in another jurisdiction. The second reason, I think, is that New Zealanders tend to just kind of sort their issues out with each other or don't. We're not that litigious as a society. And that's good, I think, for mediation. But it also means for low-level disputes, New Zealanders will either talk it through or they'll just shrug their shoulders and move on and not sort it out, rather than take advantage of a community mediation scheme. So that I think is interesting, because there's, I would have thought there's huge potential for community mediation in New Zealand, but for whatever reason, it's never taken off. So that, I think, is an interesting part of our mediation tradition as well. Maybe I'll talk for another 10 minutes. Is that right, Vikram? And then have questions after that?
Yeah, I totally your wish, because you've got enough time. I mean, whenever. Discussions will go on for that.
Yeah. Okay, I'll talk till 8:10 New Zealand time. So one important thing I think to note, if we're talking about culture and tradition of mediation in our country, is, with the exception of obviously those Indigenous traditions I've talked about, and also of commercial law, commercial mediation, all of the other mediation schemes have been pushed by the government. It's been top down. The state sets up a statutory system and the mediation comes from that. That's actually quite a theme in New Zealand's history, full stop. Because we have one central government, and it's a strong central government, often reform in New Zealand will be pushed through statutes and pushed through government policy. And mediation in that sense is part of that tradition. I must say, though, the government hasn't approached it in a particularly systematic way. It's been quite ad hoc. So when they think there might be a need for mediation, then they'll use it, and if they don't, well, they don't. One interesting example, though, I think points out how important mediation has become to New Zealand. And again, I don't know if there's been these issues in your jurisdiction or not, but New Zealand had a most unfortunate episode in the 1990s and early 2000s, where we discovered that we'd been, because of deregulation in the building industry and a number of other factors, we'd been building houses that leaked. Now, if you've visited New Zealand or know about New Zealand, it rains a lot in New Zealand, and we're not the Mediterranean. It rains a lot, and therefore, if you have a leaky home, and these leaky homes were made of untreated timber, and then they had monolithic cladding over them, and they didn't have eaves. They thought they were in the south of France or something, and they leaked, and then they rotted from the inside out. And so people bought these houses, which were just a disaster. And we're talking tens of thousands of houses, if not more. And when the government decided it had to do something because there were all these potential court cases and the legal system couldn't cope, mediation was brought in. Mediation was brought in as the first line of action to resolve the dispute. So sure, we had some important Supreme Court decisions that set the ground rules, if you like, or the environment of which mediation could operate in, shadow of the law and all that. But it was mediation that did the work in resolving those disputes, and they are largely resolved. As we, now we're in 2021. And I just like that example because it shows that mediation is now important enough in New Zealand that when we have a disaster, it was a disaster. When we have a disaster like that, mediation will come in and play a key role. Another example would be in the Christchurch earthquakes of 10 years ago that partially destroyed our largest South Island cities in Christchurch. For all of the insurance disputes that flowed from that, mediation was the main tool used to resolve those. And there were many, many disputes over insurance. So I would argue that not only do we have a long tradition of types of mediation in New Zealand going back to, well, at least the 15th century, if not earlier, we also have a growing tradition of more modern mediation traditions as well. So it's an exciting time to be a mediator in New Zealand and a teacher of mediation. We do look a lot overseas. New Zealand's always been a country that's been very aware of its isolation, both geographically and politically. And so we often try and look out and travel, and we've the Kiwis have definitely had their wings clipped over the last couple of years, because as you may know, our borders are very much closed, and it's always hard to tell, but I imagine they're going to be closed for some time yet, given the approach that a country has taken to the pandemic. But we continue to look, even if we can't travel and see, we continue to look overseas to see what's happening and to be inspired by Singapore Convention, which I am still trying to convince our government to sign up to. And some of us are trying to do that as well, because I think it's a win-win. I can't see any real downside for New Zealand. We should be signing up to the Singapore Convention. We look at different statutory regimes, different private markets. We take part in different competitions, mediation competitions. And some of our leading mediators, like Jeff Sharp, who's probably our most well-known mediator, traveled, or used past tense, the world, mediating, and now continues, to do international mediation from his office here in Wellington via Zoom. And so, I think New Zealand, we make an effort to connect with the rest of the world and what's happening in mediation. And one of the things I love about mediation is the fact that we can have people from just looking around Italy, Japan, Ghana, Israel, India, New Zealand, and we've, different legal systems, some common law, some civil, some different again. But we can all talk about mediation and we know what we're talking about. And it's like an international family, which I don't think you can replicate in litigation in the same way. And some of us are lawyers and some of us aren't. But I think that we should continue to encourage that. And I thank Vikram for organising this and for his idea, because I think the more we can do of this kind of relationship building and sharing of knowledge, the better. So thanks for listening. I think I talked for about 40 minutes. So we've got 20 minutes left to keep to our hour if anyone does have any questions.
Thank you very much, Grant. Of course, you've taken us through the entire thing. But one thing, let me tell you, whenever you meet me, whenever you come to anything I do, never look at the time, ever. I'll tell you, I do another show called Evolution of a Mediator. That
Yeah.
one episode went on for 4 hours, 7 minutes without a break. Without a break. Okay. So don't even ever look at the time. That's not allowed.
Yeah.
But interestingly, we spoke about the Maoris and the fact that there's a word called man that you used.
Mana.
Man.
Yeah.
Yeah.
Mana. Yeah.
Yeah. In Hindi, we have the same word. Man is like self-esteem and that kind of thing. So I don't know how that common word has come in. We'll
Mm.
have to, I think maybe you need to do that also. Get into
Yeah.
these common words. I mean, it's interesting. From Maoris to India. So there is a movement. I don't know how that happened. It'll be very interesting. But in
Mm.
terms of your connectivity issue that you're facing, I'm telling you very interestingly, there was there's another show that I do in Conversation with a Beautiful Mind. So I had Robert Angel from Australia. And imagine we have been trying twice to do it. We could not do it because he says the connectivity was not good because the All Blacks were playing the Australian rugby team, and he says the whole country is online. And
Yeah. Yeah.
I think the All Blacks won on that. I think that was quite majorly.
Yeah.
So
But we usually do.
I don't want to get into that.
Yeah.
But tell me, interestingly, of course, one in terms of the Maoris doing it internally, the mediation, is there some documentation of how they do it and research on that? Have you?
Mm. Yeah, my colleague Carwyn Jones at Victoria University has been doing a lot of research on traditional Māori ways of dispute resolution. And one of the interesting things with his research is looking at traditional Māori society, say in the early 19th century. So when the first British or European settlers were looking at it, and then looking at it today after 180 years of colonization, and seeing what has changed, what stayed the same, what does it mean to say Māori dispute resolution in 2021, as opposed to say, 1800. So yes, it is being documented. As you probably know, Māori was an oral culture. So traditions began to be written down with the when the church came in and taught reading and writing. But before that, and still today, it is strongly an oral culture. But those traditions come through that oral culture, and a growing body of research is being built up.
Because one aspect of the whole traditional concept of dispute resolution came up that actually most of the time it's not mediation, and they decide for the parties, they tell them what to do, the elders or whatever. So was that similar there also, do you think?
Definitely the elders, the chiefs played a key role in resolving disputes, and the wider community as well. I think an important thing to note was that the dispute wasn't seen as an individual dispute between two individuals. It was seen as affecting the whole community, and therefore the whole community had a stake in it, which is very different to the individualistic British traditions that have developed in New Zealand. I mean, I wouldn't say we're as individualistic as a society, say, than maybe the United States, but we're still quite individualistic when it comes to dispute resolution. So the Māori tradition is very different. And when those two traditions clashed in the 19th century, there was, as you probably know, there were wars in New Zealand in the 1860s. But the reality is that the Māori traditions got completely overridden by the British traditions.
And this is the situation
in the legal system. In the legal system.
And this is the situation everywhere. I'm telling you, colonization. I think on the last day of the symposium, please join us. It's a discussion on the learnings and key takeaways from the symposium, but we would also discuss this part of how colonization has affected dispute resolution throughout the world. So this is common everywhere. You come up with this, that we don't even, some like Brazil, they say before the Portuguese came, we don't even know what the situation was. So I think that aspect has played a very important role, and the effects, I think we see effects of that today. So I think that part of it needs to be looked at. But the restorative justice aspect that you discussed, I mean, what you told us about, interestingly, yesterday there was someone from Kenya, and he says that in Kenya there was a judgment which came out, and it actually went against the law and said we will endorse what that community did, and because the constitution gives validation to it. So recognition of that cultural method, or that how that whatever, it was a crime, it was a criminal act, but actually they accepted what they did, which was against what the law was. So I think that was an interesting thing. And I was looking at a constitution after that, and there is recognition of individual cultures. So maybe we'll have to look at that in a way to endorse these things, because we don't have too large of these communities left. But I think we should maybe protect them. I don't know, what is your view on that? That they're criminal, how they look at it, and should that be accepted, not accepted? How do you look at it?
That's actually quite a live question in the New Zealand legal system at the moment. We have an unwritten constitution like the UK, so we don't have the supreme entrenched overriding constitution in New Zealand. We have the unwritten, where it's kind of in bits and pieces all over the place. But the idea of what Maori call tikanga, or the way of doing things, that traditional Maori regulation, if you like, is now being brought into our case law by our Supreme Court and by other means, and therefore, things that might be what's going to happen, and what's already happening, is a clash between the law as it's written, but then the law as traditional Māori culture might see it. So what happens when they clash? At the moment, the orthodox position in New Zealand is that the written law will take precedence, because Parliament is supreme and the statutes come from Parliament. But what's going to happen is, in the courts anyway, is that as tikanga takes a bigger role, I think we're going to see more and more tension there.
So I think this Kenyan judgment, I think you must have a look at it. I'm actually re-recording that with James tomorrow. If you want to come in, it's in the morning India time. If you want to come in, because he's doing a lot of work on the ground on this on the traditional method, and because of this judgment, definitely things are going to, for them, this will be taken forward, because it's an endorsement, it's a major endorsement that we will go against the law in the country, because the constitution is supreme. In your case, obviously, you're saying a little differently there, because then the law would be different. But I'm saying I found that really interesting that a country has actually done that. I haven't heard that from anywhere else. I haven't seen that. So I think that colonization and traditional method and all that, I think we need to look at that definitely. But when you say that it is a litigious society, how many cases would be filed in a year in New Zealand?
Good question. I don't know off the top of my head. I can answer that off the top of my head. In terms of if you did it pro rata or per capita, I think it would compare quite closely to Australia or the UK. I mean, in terms of our legal culture, our colonial legal culture, very similar to the UK, and also quite, apart from the federal unitary difference, very similar to Australia as well. If you're a New Zealand lawyer, the two places you can go to and pretty much hit the ground running as a lawyer are Australia and the UK. Anywhere else gets quite challenging as a lawyer to adapt to the different, in litigation, to the different the legal systems.
But I don't know. I mean, in terms of your civil procedure code, the penal code, how old are they? I mean, have you retained what the British gave you, or have you changed that?
Yeah. 1840 came in right at the beginning. So one of the first things set up when the British, after they signed the Treaty of Waitangi with Māori, one of the first things they did was set up their Supreme Court. So the courts were considered so important in the legal system that they were there from the beginning. So yeah.
But have you retained that that penal code, or is it a different penal code now?
We do all matters are dealt with in the same court structure. So we have we have a hierarchy. So Supreme Court, Court of Appeal, High Court, District Court, but criminal, civil, all done in the same court.
Yeah, no, because my concern was the actual civil procedure code, the law relating to the civil procedure and the penal code. We have retained what the British gave us. So we have a penal code which is 1860.
Okay, right.
We have a civil procedure code which is 1908. So I don't know whether New Zealand has done that.
We've updated our ones. We've updated our ones. I mean, they're still based on those British ones, but no, we have updated them.
So can you imagine how much that colonization has? We still have it right there. I mean, the court system, like everything. I don't know. Do you still refer to the judges as my lord and like that?
So you will say Your Honor.
Okay, so
Your
we
Honor,
still
because,
okay. So in our district courts and lower courts, that Your Honor is used, but the high courts and Supreme Court, it is still my lord. We are still there.
Right.
We're still there. We haven't. So that hasn't changed too much. But I think, but when you spoke about community mediation and you said you're looking at the US, I don't think they've got it right also, because the statistics that I saw, I mean, the statistics that I looked at, quick Google search, they says only 400 mediation centers, only 400,000 matters go to those community mediation centers. I was very surprised because on the other end, my statistics in terms of the litigation is 100 million cases. So I just actually didn't understand this mismatch of figures, and people do look at the US saying that it's been there for so many years and everything like that. This is what I see when I do my research. I mean, my little quick search.
Right.
That's it. The 400,000. What is 400,000 for a country like that? So I think they've also not got it right. So if you think you haven't been able to get it right,
that's reassuring.
Not very reassuring. It should not reassure us. It should tell us what you're looking at. Why? Because I also keep talking about community mediation because I'm also trying to do it ground upwards, to create that culture and where we're going wrong. So what I've been able to look at, I mean, and how I'm doing it now, is that go down to the grassroots. First of all, this traditional part of it. Interestingly, David is here. I told you he's worked in with the traditional part of these Jews who came from the Balkans into Israel, and how that traditional system and that hybrid model. So one is, of course, that. But the other is that the people who are already trusted by communities, let's bring them as professional media. Let them make it a profession as we go along. And because the user experience is guaranteed, because if they're already being used by the communities. And I feel that user experience issue might be there because in the US, if in 40-45 years you are still going to court in such large numbers and you're not going to mediators directly, I see some mismatch there. So it's not just about having that concept of mediation in the country or having mediators there. I think who are those mediators, and is it a special profession which has to be looked at differently? I think those are questions which I am trying to answer, and I'm trying to take it. If you any thoughts on that, if you have, would love that.
Yeah, I mean, one thought I do have, I mean, I can share on community mediation, which might be common to some of your jurisdictions, is because we don't really have that community mediation part of a community. It's very hard for new mediators to get experience because a great way of getting experience is through community mediation, pro bono work, and you build up that experience, and then you can leverage off that for a career. But in New Zealand, very difficult as a mediator to get started. You've really got to go and work for the government's employment mediation team or something like that to really get the experience and the number of mediations to be credible. So there's lots of people in New Zealand who are accredited as mediators, but nowhere near enough work for them.
Because I'm telling you, Andrew Miller in his session spoke about this in the UK. He's a barrister there, and he spoke about that there were 18,000 mediators there, only 500 have work. And all
We're not quite that bad, but yeah, there's hundreds of
Oh.
mediators looking for work in New Zealand.
Because the one way I look at it is because either they're not valued, because whenever mediation, the word is used, somewhere free gets attached to it. For whatever reason,
Yeah.
I don't know. Either we are supposed to rise above everything else and we are supposed to not have houses to run. We just have to do good for society. Either maybe that is expected of us. But otherwise, the court system, that has also created problems in most countries, because there also it's almost free. So where the word goes out that litigation or courts and mediation are connected, and free and mediation are connected, I think maybe that puts people off, because I don't even know whether people even are aware of what mediation is, because we've had these discussions and worldwide, I mean, I've had people from all over and they said that people are still confused between arbitration and mediation. I don't know what the situation in New Zealand is.
Yeah, I think there's more of a confusion in New Zealand between meditation and mediation. uh, I don't think many New Zealanders know what arbitration is either. So yeah, no, yeah, absolutely. There is a lack of knowledge. Except one good thing that has happened in New Zealand over the last 40 years is we've had a very successful what we call peer mediation scheme in our schools. So where the school kids act as mediators, the older school kids act as mediators for the younger kids. And that's been rolled out right across the country. And it was operating when I was a kid, back in the 80s. And so at least, people have a vague idea of what mediation might be because they did it at school. And again, being a small country and a unitary country, you can roll out a scheme like that quite quickly and quite easily. And so that's been one positive thing.
But you want to tell us a little bit about how that structure worked? Because peer mediation is happening in a lot of places, but I think it's happening differently than the way I would look at it. But maybe because if you tell us the New Zealand way, it'll be nice. Maybe you've got it right, I would say.
I mean, it's very much a school-based thing. It's run by the New Zealand Peace Foundation to encourage peaceful resolution of disputes. And the idea is that as a school kid, if you're in your final years, you'll get a little bit of training from the Peace Foundation. And then when there's a fight in the playground, the teacher will, bring the two people in dispute to the senior student, and they'll sit down and they'll try and run a little mediation. I mean, it's pretty basic, but it gives the children an idea of what mediation might be like, and also as an alternative to having a fist fight in the playground.
So this is one of the issues that I have with that. I mean, the simple thing that you said, that the teacher brings those students to the older students in the class. I'm saying somewhere it is in the maybe subconscious mind that someone is taking us to some place, and in a way a person of authority is doing it, and I don't like authority, so I will not get into something where someone tells me whom to go to. Maybe I'm just saying, because there are a lot of factors when children are growing up, what goes into their mind. But I'm saying peer mediation concept is the best. That's where we have to start. But I have seen it in other places. It goes more into training children on conflict management and non-violent communication and that area. The actual sitting and them resolving disputes, less of that happens. And the fact that they should within themselves find that mediator whom they trust, they themselves sit with that person, no one comes into that picture. I want that atmosphere to be created, because that is exactly the way we want mediation to go forward. So when I said that they in the communities and all, they identify people whom they trust, same thing with the children, because they already do it. They already identify those right people themselves. And like I said, the user experience is guaranteed if they have trusted the person. And maybe after the session, if you have 2 minutes, I'll take you through a clip with some children that I was speaking to, and you will notice no peer mediation in the school. And that kid will tell you exactly what they did, and you will be very happy that without any training, nothing, they are doing mediation, and very successfully. That whole thing that she tells us, very successfully. So I think maybe the way it's gone on, I think we need to maybe look at it. I relook at it somewhere maybe. So but also in the Singapore Convention, they're saying not signing it. Is there resistance from, what do you think, lawyers and all? Are they not wanting it? Is there from that end or otherwise?
For Singapore Convention?
Yeah.
No, it's apathy. It's apathy, not resistance. Yeah, no, it's just, it's just quite low down on the list of the government's priorities. So it's a matter of bringing it to their attention, and they're just not particularly interested. I suppose they don't see a huge amount of benefit for New Zealand, so it's convincing them that there will be benefits is the main thing. But yeah, no, it's definitely apathy rather than resistance.
Sometimes I feel that one aspect of the Singapore Convention that you can actually enforce a settlement agreement in a country where it has been ratified, even though you are not in a country which has signed it. So maybe country says not a problem, you can go there and enforce it. We don't have to enforce it here. Maybe that might create some of a lag between when countries sign it. I don't know. Let's see that how that happens. But when you talk about, like I said, mediation in law with law students in colleges there, are we going beyond that? Are we saying let's teach mediation to in all colleges? Is there some movement on that?
Mediation, to the extent that it's taught in universities, or it's in the law schools. It's not even in every law school, but it sits in the law schools. There's a little bit taught in business colleges, but it's pretty much seen as something that you learn if you're doing law. But even then, most law students wouldn't learn it either. So the educational institutions have been pretty slack, really, in promoting mediation. I mean, some have been better than others, but as a it hasn't had a lot of overall support.
Okay, so there is, of course, that, because I feel that we need to bring in everyone into that. I mean, in terms of mediators and the process and everything, because it'll be used everywhere. So I don't know whether, because most countries I think haven't gone beyond that, because India has just about this year introduced it in law schools. So I would think it should be much larger, but let's see how it goes. Because we, of course, are a different scale in terms of pendency in courts and number of matters. We're at a different level altogether. So I don't even want to get into it. But let me throw the figure to you. 43 million cases are pending in courts. Right. Okay, so just give you an idea to take so that numbers. So now, closing address, closing words, please, Grant, whatever you want to tell us as a closing remark.
Yeah, no, I think I see mediation's potential as continuing to grow worldwide. I think, given the pressures on the courts and the way in which mediation can successfully resolve disputes, I think it's going to continue to grow, and I think New Zealand's going to be part of that. We've always had, for some time now, a strong and robust group of mediators in New Zealand, and we've got a high standard of practice. What we need now is to have that backed up by the teaching and the scholarship and the kind of more holistic things that make for a overall strong mediation culture. And we need to, as I tried to sort of point out at the beginning, we need to harness those Indigenous traditions and learn more about them, as in non-Māori or non-Moriori, to learn more about them. And I think that'll set us in good stead for the future.
Yeah. The only thing I look at it is because online mediation has taken off, and Jeff Sharp is working online, but how does a time difference, how does he manage the time difference? I want to understand that.
With great difficulty. It's, he's, a lot of it's in London. It's, it's not, it's morning and when it's evening there and vice versa. I mean, this is quite a civilized time. It's just gone 8:30 at night. So, but yeah, for some of those European countries and the States, it's quite difficult.
No, because that's why I had these sessions in the morning, because the problem is all the other things I've been doing have been in the evening. And Southeast Asia, not just Australia and New Zealand, Southeast Asia also becomes a problem because it's late night. So I want people to come in, but let's see, this is the starting point, get people involved into discussions as we go along. That show that I do, like I said, Evolution of a Mediator. Now that Robert Angel came in, someone from Australia comes in. Same way New Zealand, I think we'll have to just, I'm trying to get as many people from all over, but time difference, I can manage, because morning for me it's okay. Morning for me is the evening for you, so we can do that. We should have more interactions. That's what I'm saying. That, and everyone with lots of thoughts, ideas should be thrown, and let's see, take it forward in a good way. So thank you, Grant. Thanks a lot.
Yes,
Nice
thank
session,
you.
educative session. Professor has to give us an